Welcome. We are ready to begin the UAW FCA Ford General Motors Legal Services webinars on beneficiaries. We have received a number of questions from you, and we have incorporated many of them. At the end of this webinar, there will be a brief survey. Please take a few minutes to complete this survey. Your feedback is important to us. We will begin today by introducing each other. Our panelist today is Dave Savard. Dave's first job involving the UAW was as a proud member of UAW Local 372 at the old Chrysler Chemical Plant in Trenton, Michigan, making brakes, while he attended Eastern Michigan University. He earned his law degree from the University of Toledo in 1982. After a stint in the Monroe County Prosecuting Attorney's Office and the Monroe County Senior Services, Dave joined the former UAW Legal Services Plan in 1985 as a staff attorney, where he eventually became a managing attorney. Dave is currently the managing attorney in the plan's Wayne, Michigan office. Welcome, Dave.
Thanks, Linda. And my colleague, Linda Carr, is a graduate of the University of Michigan. Linda obtained her law degree from Wayne State University School of Law. Linda worked as an estate and gift tax attorney with the IRS and was a judicial attorney for the Wayne County Circuit Court prior to joining the former UAW Legal Services. Linda began her tenure with the former UAW Legal Service Plan as a staff attorney and was eventually promoted to managing attorney. Linda has practiced in and trained other attorneys in the areas of bankruptcy, family law, tax, probate, and real estate law. Linda is currently a managing attorney in the new plan's Dearborn, Michigan office, and she's handling family cases right now. Welcome, Linda.
Thank you, Dave. Okay, let's get started. Dave, can you tell me, who is a beneficiary?
Well, a beneficiary or beneficiaries are the individuals who may inherit assets you own upon your death. So they may inherit under your will or a trust or by beneficiary designations that you sign for retirement accounts, bank accounts, life insurance policies, or even for real estate. So these are the things we'll be discussing today.
Okay. Well, suppose I have a will or a trust. How does naming a beneficiary work with my will or trust?
Well, the beneficiary designation will control. So anything you have a beneficiary on, that's going to pass directly to the beneficiary. And that does not, the will does not control those assets. So wills, trusts do not control those particular assets. The thing that's important to remember is you want to make sure that your beneficiary designations are consistent with your estate plan. So you want to make sure that everything jives, so to speak, that the will and the trust or your beneficiary designations are consistent.
Okay. Well, Dave, what is accomplished by naming a beneficiary?
Well, when you name a beneficiary on a piece of property, it causes the property to pass outside of probate. So people are always concerned about probate. You avoid probate by designating a beneficiary on those particular assets. They pass outside the will or the trust directly to those you've designated. It's not subject to the probate court, and it's generally not taxable to the beneficiary upon receipt. So the monies that are received are tax-free in most cases. They're commonly used for bank accounts, for 401ks, life insurance, and real estate.
Okay. Well, can you offer some tips for designating beneficiaries?
Well, the owner of the property is the only one who can designate the beneficiary. Okay, so as owner of that particular piece of property, you designate your beneficiaries. This is typically done by a form that you obtain from your bank or your 401k holder, life insurance company. You fill out the form. It can also be done by a deed on pieces of real estate. If you do this type of setup, though, it's very important that you keep a copy of that designation. You want to make sure you have a copy of it, and you want to make sure your beneficiaries know where it is. They need to know where to go to retrieve the money when you pass on. We've seen situations where sometimes people don't tell their loved ones where they put these designations, beneficiary, and of course that causes a problem. They may never get the money. Designations can be worded in different ways for different types of assets. You can do different percentages. And all of these types of setups provide that the money will go directly to the person or persons named outside probate.
Okay, well, Dave, let's talk about some of the different types of designations. Well, first one is payable on death, PODs. Can you explain to us what that is?
Well, POD, payable on death, is what is typically done with your bank accounts. So if you have a bank account or a CD, checking account, any type of account such as that, what you do is you can get a form, you can designate your payable on death beneficiaries. They will get the money when you die. You can set it up any which way you want in terms of percentages, or it could be evenly, or you can do it to one person or more than one person. So it's up to you.
Okay. Transfer on death, TOD. Exactly what is that?
Well, the transfer on death setups are similar to the POD, but those types of setups are typically used for investment accounts, stock type accounts, or real estate that you may own. The asset will be paid again directly to the beneficiary that you designate.
Okay.
And an example would be that you might do is, say, a 401k. You could make it 60% payable to Jane and 40% to Joe, so you have freedom to do that in whatever percentages, or even Steven, whichever way you think is appropriate.
Okay. Okay. What about beneficiary designations?
Well, the beneficiary designations are used typically on life insurance. So most folks are familiar with naming beneficiaries on life insurance. You get a form, you designate who you want to leave it to in terms of your loved ones. Okay. The proceeds pass directly to the beneficiaries upon death. Typically, you have to provide a death certificate for that. You can do it any which way you want, once again, in different percentages. The example there, 40% to Jane, 30% to Joe, 30% to Janice, or any other combination that you'd like to make.
Okay. So if I understand this right, payable on death is used generally for bank accounts and CDs. Transfer on death is typically used for investment accounts and real estate. And beneficiary designations are used basically for retirement plans and the insurance policies.
That's right.
All right. So now, Dave, what is the difference between a primary and a contingent or secondary beneficiary?
Well, your primary is your first choice. So you designate your primary beneficiary on, say, a life insurance policy. That's the person who will take when you die. In some cases, people will put a contingent beneficiary, a backup beneficiary. So you have your primary, you have your secondary. If you die, the primary gets it. But if your initial beneficiary has predeceased you, then the money will be paid to the contingents. And the typical example we see of that is where you name your spouse, and then you name the contingents your children. So that's how you would typically do it in most cases.
Okay. What are some of the things to consider in choosing a beneficiary?
Well, first of all, you want to think about who you want to have get your property when you die. Okay, so you want to name the person that you want to have get it. But you also want to think about your entire estate plan. You want to think about, what if I have in my will or my trust? You want to make sure that you've got the property going fairly in whichever manner that you want it to go to those individuals that you want to have get it. So you basically tie those things in. You have to consider whether you want it to be a even split, or whether you want one child to get more than another. So you can set up your beneficiary status in that manner. You should decide whether or not you want certain accounts to go to some people, maybe a different account to go to someone else. You also need to consider whether or not the beneficiary is able to handle the asset. So if you have, minor children or disabled children or beneficiaries, that needs to be considered. These are all things that you can discuss with your attorney when you meet with us at a plan meeting.
Okay. Well, let's now move on to talk about some of the pitfalls to avoid in choosing a beneficiary. Say I have 3 children, and I'm naming one as the beneficiary because I think she's honest and she'll take care of the business and she's taking care of help me along, and that she will split it among the siblings when something happens to me. Is this a good idea?
Well, it's really not a good idea. The reason for that would be that if you name just one child, it's going to go to that one child. Okay. Now, maybe that one child will split it up with the other kids, but maybe they won't. So it's important to understand that if you name just one, that one gets it, and legally it belongs to that person. that trumps the will. So if you have, even if you have a will that says I leave everything to my 3 kids share and share alike, but you only put the 1 kid on there, that 1 child's going to get it, okay, and will not have to legally share. So it's important to understand that concept. This can always create problems within families. You sometimes see this. A lot of times there's misunderstandings. People think that the will, if it leaves it to 3 people, that's what controls, but that does not control. That beneficiary designation controls, and that's what's important to understand.
Okay. Well, Dave, what happens if I name a minor child or my minor grandchild as a beneficiary?
Well, a lot of times if you have someone typically under 18, okay, the insurance company or the bank is not going to hand that money over to a 7 or 8-year-old, okay? That's going to cause some issues. So what you can do to avoid that sort of problem if you're leaving money to a minor is you can designate a guardian. That can be typically done within your will, and that would then be the person who's going to oversee the property for the benefit of that child. You can also name your estate as the beneficiary. So if you name your estate as the beneficiary, then the insurance companies say they'll turn that over to the probate estate, and then the will designate who's the person to be the personal representative or guardian and handle that money. You can also set up a trust or a setup within the will that will provide that the money can be held and managed and what the money can come out early for. You can even set it up so the money won't be paid at 18. It could be delayed till the child turns 22 or 25. Typically that's designed so that if there's a kid in college, money will come out to pay the tuition, the books, that type of thing.
Okay. Well, Dave, what happens if I have a disabled child? Does this raise additional concerns?
Right. Well, if money were to go to a disabled child, first consideration is, well, would this person, this child, be able to handle that money, you know, in light of their disabilities? There's also the issue if a person who's disabled and is on government benefits of some kind, you know, maybe Medicaid or SSI type benefits, have strict guidelines for assets that if they get a big chunk of money, that may bounce them off that benefit and they won't be able to continue with their public benefit. So what the situation there would be is you can set up a trust that would delay the distribution or pay it out in smaller increments so that they can maintain their eligibility for that type of thing. So these types of trusts are done, and these are things that, you know, we can talk about if you contact our offices for assistance.
Okay. Well, naming a beneficiary can be a bit more complicated than it appears.
Right.
So let's talk about some other issues that arise in relation to beneficiaries designations. First, what happens if I forget to name a beneficiary on one of my accounts?
Well, if you don't have a beneficiary named or a beneficiary has died and there are no contingents, then your will is going to control who would get that property if you have a will. If you don't have a will, then the law says who gets it. You know, okay. Basically the states have setups that set up what we call intestate succession or distribution if a person dies without a will. What may end up happening under those circumstances is that the property may not go to those you want to have get it. So it's important to get that beneficiary on there. Also, assets that pass through probate or pass through trust may be subject to claims by creditors. So with some assets, such as retirement plans or life insurance, there's also legal setups sometimes under the law or under the contract that provide for default beneficiaries. And again, that may be a problem because it might not be the person or persons that you want to have get it when you pass on.
Okay. Well, one of the mistakes we often see is that people forget to update the beneficiary designation. For example, what happens if I change my mind about who I want my property to go to, but I forget to change my beneficiary with my bank, for example?
Well, the way that's going to work is whatever the beneficiary designation is on the form, that's who's going to get it. So even if you intended to change it, you may have even talked to the family about, well, I think I want Bob to get this instead of Bill. Whatever's on the form, that controls. Okay. So if you're thinking about changing it, don't delay, get it done. Even if you change your mind, it's not enough. You have to get that beneficiary form changed. And you should also be aware that, you know, certain things in life, significant life events should remind you to check beneficiary designations or make beneficiary designations.
Okay. Well, let's move on to that then. Let's talk about some of the important times or events in our life to update beneficiaries. What about when people get married?
Well, that's always a good time to take a look at the policies and the setups on your accounts as far as beneficiary goes. You're going to want to make sure that you've got the proper designation. Typically, a person would want to add their spouse as the beneficiary, but that's not always the case. Sometimes you have a situation where it's a second marriage, for example, and you may want to leave the beneficiary designations as they originally were set up, maybe for children from a prior marriage. You may also want to consider maybe giving some of the money to a spouse and also to leave some to your children. So these are all things that you can set up. But again, it's important if there's a marriage that you take a look at these things.
Okay. Well, we all know that marriages sometimes don't work. So what happens if the parties get divorced? Is this a good time?
Yeah, well, once again, it's a major life event. Anytime something like that were to occur, you want to make sure you review those beneficiary designations. Oftentimes people will divorce and property will get divvied up in the divorce, but they forget to change the beneficiary on their policies. So you want to make sure you review that, make sure that you get your X off that policy and leave it to whoever you want it to go to now. Because it is possible that an X could end up getting the proceeds if you don't make that change. You might want to change that to your children, or you may want to change it to a new spouse if you're remarrying. So these are all things that should be reviewed.
Okay. Well, speaking of that, our family continues to grow. What happens if we have children?
Well, if you have new children in your family, again, that may give rise to changes on your beneficiaries. You may want to add that new child. If you don't make that addition, then it'll go to the others that are already named to the exclusion of the child that you didn't put on the policy. So that's certainly one of those events. And you want to make sure that you double check that, again, when there's a major life event.
Okay. Well, Dave, I've taken care of and I put beneficiaries on all my accounts or assets, I think. But what happens if the person I named as a beneficiary dies before I do?
Well, if the person that you name dies, then we're looking to see if there's contingents, as we talked about before. So if there's a contingent beneficiary, that person will then receive the money. If you have a situation like that where your primary beneficiary dies, or even if your contingent beneficiary dies, you may want to get a new form done, get everything updated, get a new primary, a new secondary, change it as appropriate. If both of the primary and the contingent have died before you, then as we talked about before, if you haven't made any new designations, that's going to pass through your probate estate or through your trust perhaps. So it's important to keep tabs on all these things.
Okay. Well, I guess always remember though, whoever you name or whenever you change your beneficiaries, you should also make sure that there is a record of your accounts and beneficiaries and that someone knows where that information is kept. Okay. Okay, well, let's move on. Now that we have talked about how and when to name beneficiaries, let's talk about some of the assets we should have beneficiary designations. What kind of beneficiary designations should we complete for bank accounts or CDs?
Well, we touched on that briefly before. The payable on death designation would be the setup for bank accounts, CDs, any type of account such as that, checking accounts and so on. So that's an arrangement you make with your bank and with you, where you go down there, you get your form filled out, you designate your payable on death beneficiaries. You want to make sure that you get all of those people named that you want to have get the money. Okay, if you want 3 of your kids to get it, get them all, get all of the 3 on there, not just one. If you're not sure if you did one of these forms in the past, makes sense to contact your bank, double check. If there is a payable on death designation, get a copy of it. Once again, you want to make sure that your beneficiaries know where these designations are so that they can follow through on it if you pass on.
Okay.
Okay.
Well, what happens to the bank account when the holder dies and there is a POD?
If there's a POD named on there, then your payable on death beneficiary would go down to the bank, take a death certificate, and with that proof of death, then the money should be delivered to the beneficiary you've designated.
Now, Dave, many people have 401ks, and there are special rules for 401k beneficiaries. Can you tell us how these work?
Well, 401ks have certain protections for spouses by law. So the spouse is the primary beneficiary typically, and the default beneficiary typically on these types of setups. If you want someone other than your spouse to get that money, then the spouse would have to sign a waiver in
Okay.
order for you to designate beneficiaries other than the spouse. So this could be done when you first open your 401k if you're married. If you are getting married, then you could have that designation set up again to make sure that it goes to the proper beneficiaries. But bear in mind, if you don't do anything at all about it, then your spouse is the default beneficiary on these 401ks. Another thing to remember too is even if your spouse remains as the primary, you can still designate your backup or contingent beneficiaries.
Well, what happens when the 401k account holder dies?
Well, at the time that the account holder dies, the beneficiary can contact that account provider. The typical scenario there would be that a form is filled out, death certificate is presented to reflect that the person who owned it has since passed on, and then those funds are distributed according to the forms, according to those beneficiaries designated.
Okay. Well, it seems like beneficiaries have to make some important decisions, don't they?
Right, because there are certain tax ramifications with these 401ks. So if the spouse is the beneficiary, while the option is there to maybe take all the money in a lump sum, that may not be the best approach. So the option there would be that that money could be rolled into an IRA. At that point in time, then the spouse could take it in increments over the course of their life based on the life expectancy. And then that way you're getting some stream of income and the tax bite would be less.
Okay. Well, what happens if the beneficiary is not the spouse?
Well, it'd be a similar situation. If it's, say, one of the children is the beneficiary, then that beneficiary could take a lump sum distribution if they wanted to. But again, there'd be a sizable tax bite on that. The beneficiary could establish an inherited IRA.
Oh, okay.
Okay, and by doing so, then same situation, they get the money, it's put into the pot, so to speak, that they own now,
Okay.
and then they can draw the money out over a period of time based on their life expectancy. So again, that minimizes the tax bite. So, it makes sense to always review these things if there's deaths in a family, or, periodically double check to make sure you've got proper beneficiaries.
Well, for more information on 401ks, we suggest that you view the plan's 401k webinar. And of course, always consult your plan attorney. So Dave, let's talk about life insurance. What happens with life insurance proceeds after the death of the policyholder?
Well, same situation. If the owner of the policy dies and you're the beneficiary, then you're going to want to notify the company. There's typically some forms to fill out and some paperwork. The death certificate has to be presented, as in all cases. At that point in time, the money is paid out. There are no tax consequences on the payout of life insurance, unlike the 401k, so it's tax-free. However, there is the possibility that if there was some interest that had accumulated, then there might have to be some taxes paid on any interest that might have been paid out.
Okay. And just remember again, make sure that there's a record of your accounts and beneficiaries and that someone knows where to find them.
Right.
Okay. Well, now, Dave, some states allow people to pass their residency and other real estate by beneficiary deeds, sometimes called a ladybird deed. Can you tell us more about these types of deeds?
Right. Well, these deeds are a good way to get your real estate onto your loved ones after you die. Okay. You designate a beneficiary. It's a special deed. We're doing a lot of these now. The deed gives you continued ownership. So that's the nice thing about it is you remain in full control of the property. You remain the owner.
Okay.
You have full rights to sell it, gift it, lease it, do whatever you want to do with it. So the way these things typically read is it's a deed from, say, John Jones to John Jones, right back to yourself for a lifetime with an unrestricted power to convey the property or sell the property during lifetime. It then goes on to state that if John has not conveyed the property or sold the property prior to his death, then it will go to those named beneficiaries. And there's different ways it can be set up for ownership. It can be joint tenants or tenants in common. So those are options you can discuss with your attorney. So when the owner dies, the property is transferred automatically. Basically, it requires the recording of the death certificate at the Register of Deeds. And at that point in time, the new owners are the beneficiaries. Not all states, though, do allow these deeds, so it's something you should discuss with your attorney. Michigan, for example, does have that set up. Florida, but different states, may have different rules.
Okay. Well, Dave, what are some of the advantages of a ladybird deed?
Well, the Ladybird deed has a lot of advantages, besides the fact that you have the full authority over your property, that you keep your
Okay.
property, you could sell it, do anything you want with it. There's no co-owners, you're the sole owner of the property.
Okay.
You keep the right to profit from it, lease it, do whatever you want to do with it. You can sell it. You can also change your beneficiary. So you could put beneficiaries on now, in a couple of years decide, well, I want to change that. And you can do that at that time. It's also advantageous in that it avoids any gift taxes. If you were to give property to somebody during your lifetime or add people onto your deed as co-owners during your property, there may be gift tax consequences to that. So the Ladybird deed avoids those problems. It also is good for Medicaid planning, for planning to get, nursing home care and things of that nature, because it keeps the property in your name, which means that it remains exempt from being counted by the Medicaid people. And then when you die, if the property passes directly outside of probate to your beneficiaries, there's no way for Medicaid or any other creditors for that matter to file claims in the estate to get reimbursement.
Okay. Well, how does a Ladybird deed work with the rest of an estate plan?
Well, once again, the Ladybird deed trumps any wills, trusts, anything like that. It takes precedent over that. The will controls whatever is only in that probate process, what's specifically in the will. If the property passes via Ladybird deed to your beneficiary, that's what controls. So even if you had a situation where you might have put in a will that I leave it to Tom, Dick, and Harry, if you have Tom on the Ladybird deed, that controls. So that's all. It's true with any other beneficiary designation. So it's important to put on that deed all of those that you want to have inherit the property. It doesn't have to be one kid, it could be all of the kids.
Well, does using a Ladybird deed have any tax advantages or implications?
Well, yeah, it does. The Ladybird deed provides added tax, benefits, shall we say. You've got a situation, as I mentioned before, where if you put a deed in place where you're giving property away or adding kids as co-owners, that has tax ramifications. But because the property does not pass to the beneficiaries till you die, there's no gift tax consequences to it.
Okay.
The property also gets a stepped up basis. So when the property passes to your loved ones upon your death, they take the value date of death. Okay, they don't have to go back to when you first bought it for, say, 10 grand. Maybe it's worth 100 grand when you die. They start with that. So if they turn around and sell the property then, quickly after you die, typically within a year or so, there's not going to be any capital gain taxes to pay either. So there's a lot of advantages there as well.
Okay. Well, are there any times where a Ladybird deed should not be used or would not be a good idea?
Well, there are some cases where it could be a bit of a problem with it. So for example, if you had a situation where you had a large number of children, okay, maybe you got 8, 10 kids, what would happen at that point in time is all of those children become the owners now when you die, and they're going to have to work out what's to be done with it. So sometimes it's hard to get 8 or 10 people to agree on what's to be done. Will it be sold? Will we keep it and maybe use it for rental or whatever? So the important thing there is that beneficiaries are going to have to work together and decide what they want to do with it. Now, if the property passes to your estate or through your estate, then at that point in time, the personal representative is the one who oversees the process, would be the one to decide and sell it and do those types of things. Okay.
Well, what happens if there are liens on the property?
Well, if there's liens on the property, then the property is inherited by the person or passes to the person, and they take that property subject to the lien. So there's considerations there. They're going to have to either pay that mortgage off or continue to make the payments on it. If there's a large outstanding mortgage, then the beneficiary is getting less than what they may think. So you run into situations sometimes where, again, you have to look at the whole big picture of your estate plan, who you're leaving certain property to. Maybe this account's going to this person, this property's going to another. Okay, it may turn out to be not as fair as you might have hoped. So for example, if you had a situation there where Jane wants to divide her estate evenly between her 2 kids, she's leaving her child Mary 75% of her $200,000 estate in her will. She signs a Ladybird deed, for example, leaving the home valued at $150,000 to her son John. Well, there's a mortgage balance on that property of $110,000, so it's worth less than you would think. So the result is Mary is going to inherit $150,000, And John, in effect, will only get 90,000. So this doesn't shake out the way maybe the deceased intended. So these are all important things to consider when you're doing beneficiary designations on deeds or any other property for that matter.
Okay. Well, Dave, we have some additional questions from the audience. Can you tell us what is the difference between being an active employee or retiree as far as my beneficiaries designation?
Well, there wouldn't be any difference at all. You designate your beneficiary while you're working or after you retire. That's what controls, and you can do that at any time. You can do it now or later.
Okay. All right. Well, thank you for your participation today. I hope you have gained a lot of information. And remember, it's your plan, the UAW Legal Services Plan. So call us to open up a case at 800-482-7700. And again, thank you for participating. And
Thank you.
again, please take a few minutes to complete the survey at the end of this webinar. Believe me, your feedback is very important to us. Thank you. And thank you, Dave.
Thank you.